Guys, welcome back. Great to have you. We'll get to Fannie in a minute, but I want to start with the Supreme Court decision yesterday, 9-0, that Trump should stay on the ballot in Colorado, and this will affect him in all the states. Anybody trying to kick him off is going to have to deal with this. But as it turns out, there was more in the decision, and it just broken when we went to air yesterday, than we really knew. And I'll paraphrase it from Andy McCarthy's National Review piece, where he said, okay, it's for sure they held that states are not empowered by the 14th Amendment to remove alleged insurrectionists from the ballot. That is clear. All 9 agreed on that. States can't do it. Can't have the patchwork of Colorado finding differently than Georgia, Florida, et cetera. And then 5 of the justices went on to say, the only conservative who didn't join in this is Amy Coney Barrett, that this insurrectionist piece of the 14th Amendment can only be enforced against someone who's been convicted of an insurrection, who has been convicted of an insurrection. And that is the piece that drove the 3 liberals nuts. So they wrote their own decisions, Sotomayor, Kagan, and Ketanji Brown Jackson, saying, you went too far. I read this to the audience yesterday. There was no reason to get to that. And you shouldn't have gotten to that. And the reason they're so mad about it, Mike, is that what this does is it makes it impossible for Congress, really at any point, at any time that's going to affect Trump, to invoke this clause against him again. Because the majority of the Supreme Court said this piece of the Constitution, the 14th Amendment, saying you can't run if you're an insurrectionist, can only be enforced against someone convicted of an insurrection. And Trump hasn't been convicted. He was impeached for things in the House. He wasn't found guilty in the Senate. He hasn't been indicted for insurrection anywhere. And so this really was even better for Trump than at least we first thought when we looked at it yesterday. What do you make of it?
Well, the Supreme Court's exactly right, and they're following a precedent from more than 150 years ago called the Griffin's case. And it's not a controlling precedent, it's a persuasive precedent where then Chief Justice Salmon Chase, riding circuit as a circuit judge, not a Supreme Court justice, decided a case where it was these exact patterns where someone was they were trying to disqualify a Confederate who engaged in insurrection or rebellion, and Salmon Chase said no. In order to do this, Congress has to pass a federal criminal statute for insurrection or rebellion with a disqualification clause, which Congress promptly did, and it's on the books now. The most updated version was 1948. And it's still in the books. And if Jack Smith or the Democrats want to get rid of Trump, if they fear American voters and they don't want American voters to decide the election on November 5th, 2024, then Jack Smith better get moving. He better charge Trump with insurrection under this statute. He better get a federal grand jury to indict, a federal jury to find guilt unanimously, with evidence beyond a reasonable doubt, a federal judge to convict, and that conviction upheld on appeal. That's the only way you can disqualify under Section 3 of the 14th Amendment. You have to ask yourself this: the January 6th Democrats and the Biden Justice Department have spent tens of millions of dollars hunting for insurrection evidence on Trump, and they charged Trump with many other things, but they couldn't charge Trump with insurrection because the evidence doesn't exist. How many insurrectionists go unarmed and into a nation's capital, get to the Senate floor of the nation's capital, and walk through velvet ropes, follow police direction, take selfies, and don't burn down the damn place? January 6th was a lawful protest permitted by the National Park Service that devolved into a riot, period, full stop.
And what Andy says, Dave, is that this means that congressional Democrats would not be able to, on the next January 6th of 2025, right after we've had the election, that was the day they certified the vote, Mike Pence counted the votes, they would not be able to refuse to ratify a Trump victory on the grounds that he is an insurrectionist. The Supreme Court just took that away from them. And this is one of the many reasons why some on the left are very angry at the Supreme Court for this decision, and in particular for that additional step the 5 conservatives took.
Well, first off, good to be with you, Megyn. It's nice to see Mike so happy for once. I can see why. He's got two really good Supreme Court decisions under his belt, plus good polling numbers. So congrats, Mike. This is your halcyon period. And I tell my Democratic friends, this is what you get when you listen to Susan Sarandon for your political advice and end up voting for Jill Stein. You get a Supreme Court that doesn't know the idea of judicial restraint. So instead of just ruling on the issue in front of them, they went further. And the one thing I would disagree with, Megyn, is, and I have a lot of respect for Judge McCarthy, but I didn't see that in the opinion where you have to have a conviction for insurrection before you can bounce someone from the ballot. And I read this and the concurring opinions, and here's what how I interpret it is that what the Supreme Court said is that only Congress can enforce Section 3 of the 14th Amendment. Now, there's nothing in Section 5 that says it's exclusive to Congress, but the Supreme Court said only Congress. So if that means that there is someone who did engage in insurrection and was convicted of insurrection, that states cannot bounce that person off the ballot. Only Congress can establish a mechanism. And if Congress doesn't establish a mechanism, then tough luck. Plus,
well, wait, let me just answer that. You're right. I mean, I simplified it for the audience, but what Andy is saying is that right now, the only existing statute that could be used is the penal law against insurrection. That's the only law in the books right now that could be used. And Trump has not been charged as an insurrectionist. So yes, going forward, sure, they could change the law, but you tell me how in a Republican-controlled House, and we all remember Schoolhouse Rock, it's got to go through the House and the Senate and be signed by the president to become a law, they're going to change the law between now and November.
Oh, there is a less than 0% chance they're going to do that. There is not going to be a change. Congress is not going to act. Congress is going to do what they're best at, which is do nothing. So what this court decision did was to also tell federal courts that you don't have the power to disqualify a federal candidate from office because of insurrection. Even if they're convicted of an insurrection, it's going to be up to Congress to create a mechanism to do that. And so that takes the power away from state officials and judges until Congress acts. So that's why it was such a broad ruling, such a powerful ruling by these justices, and why even Justice Amy Coney Barrett said, hey, let's not go this far. Let's use some judicial restraint. But Katie barred the door.
Mike's shaking his head no. Why?
Well, I would say, I think Dave is right that you can have a civil component to this, because the predecessor to this criminal statute on insurrection or rebellion, there was a civil statute. So it could be either civil set up by Congress or criminal. So that's, well, according to the Griffin's case, it has to be criminal, but there was a civil component to this. So, that's, he could be right there. I would say this on, could Congress right now, could federal prosecutors right now get rid of people who engaged in insurrection? And the answer is yes. They would have to be charged. Those insurrectionists would have to be charged under this federal criminal statute for insurrection or rebellion with a disqualification clause that's already on the books. Congress wouldn't have to do anything new. It's just the Biden Justice Department would actually have to come up with evidence of insurrection or rebellion.
Well, like Mike, take for example some of those J6 defendants who actually were charged with insurrection and found guilty.
Well, I don't know if they were charged with insurrection. I think they were charged with seditious conspiracy, which is different.
Oh, right. You're right. So that wouldn't do it. So, but if you were to have a January 6th defendant charged with insurrection and convicted of insurrection, the Supreme Court has basically said those people are not going to be president.
Correct.
Okay.
But Dave, maybe if you go after Hornman or Lectern guy, my two favorites for presidents, you could take them out with that statute.
Well, Megyn, Mike is right that no one has been charged with insurrection. They've been charged with seditious conspiracy, which is different. But now, correct me if I'm wrong, Mike, the statute that says that insurrection is a crime contains a section that says you cannot run again. I thought that was what was in the 14th Amendment, Section 3. The statute actually prohibits you from running again if you violate that current statute on the books.
My head is starting to hurt.
Insurrection or
if you've
rebellion
lost me, you've definitely
hasn't-
lost my audience. Just give me the bottom line without doing in-depth statutory analysis. I mean,
So if you want to
go ahead.
disqualify for insurrection or rebellion, there is a statute on the books, a federal criminal statute on the books right now. The latest version was 1948. It's been on the books for a long time. You charge under insurrection or rebellion, and there is a disqualification provision in that statute. So if you're convicted of insurrection or rebellion under that statute, you are disqualified.
Okay, but that hasn't happened to Donald Trump. That's the operative point. And while they could change the law going forward, there's zero chance that this House, controlled by the Republicans, is going to be on board with that. So for now, Trump is protected. And not just for now. I mean, all the way through the election and potentially, up to January 6th, when, he's if he wins, he's going to have the vote certified and so on. All right. So that's a very good thing for Donald Trump. And it's very bad for people like Michael Luttig, Lawrence Tribe, who, since this idea came up, and Luttig was one of the ones who did it, he was, I think it's fair to say he's a respected appellate court judge. But this is a cockamamie idea. And he was put, it's not like you see Michael Luttig all over cable news on a normal basis, but he was a star on cable news. Lawrence Tribe, he's been on MSNBC. He's a very hardcore anti-Trump guy. But here's just a flashback of some of the media and the experts embracing this wonderful idea, which, as I point out, while they were split on just how far they went, 9 out of 9 did say states are not empowered by the 14th Amendment to remove alleged insurrectionists from the ballot. Watch this in Side 8.
Colorado is executing its state's rights to decide who should be on their own ballot.
It's grounded in the Constitution.
That language in the Constitution, Jim, simply could not be any clearer.
This is a slam dunk.
The former president is not eligible to be president again.
Trump incited and therefore engaged in an armed insurrection against the Constitution.
Trump is indeed ineligible to be president.
Donald Trump engaged in an insurrection against the Constitution.
Donald Trump cannot be president.
For under the Constitution, he cannot be our president again.
That engaging in insurrection has disqualified himself from holding any future federal office.
Will the Supreme Court agree with themselves?
We're confident the Supreme Court will reject that claim.
Or not. That was courtesy of the Washington Free Beacon. But for our audience, both guys are laughing. Both lawyers are laughing. It is kind of funny. Look, we'll see whether those experts now go back in and say, gee, even my side ruled against me on the critical point. Dave, it was a resounding defeat.
Yeah, boy, the hazards of videotape, that it looks like me. It looked like me when I said that the Supreme Court would deny cert in the absolute immunity case, so I've been there.
It's just, there's no getting around it. And that's because it really was cockamamie. It was a real reach. And I forget what I found. I remember looking into Luttig. I think he's more right-leaning, but he's a never-Trumper. He's a never-Trumper. You have to, when you look at the conservative leanings of these judges, Mike, you have to figure out, okay, it's not enough just to say they're conservative and therefore I need to take them seriously on an anti-Trump move. You do have to figure out one step beyond that. And I'm sorry to make it all boil down to politics, but in this case, it does.
Yeah, so Judge Michael Luttig is a total goofball. He lost his mind when he got passed over for the Supreme Court by George W. Bush. I was in the White House at the time. He got mad. He resigned from the bench, and he's just been a bitter, washed-up loser for years and years and years.
Dave's raising his hand. Yes,
all right.
Go ahead.
Here I am defending the Federalist Society ultra-conservative Judge Luttig. Look, here's the thing. This wasn't a complete victory for Trump at the Supreme Court in that they did not address the issue that Trump wanted them to address, which is whether or not he engaged in insurrection. They left that to the lower courts. And by doing that, the finding from the lower courts is that Trump did engage in insurrection. So where Luttig and others are coming from is that if you did engage in insurrection, the plain meaning of the text of the 14th Amendment, Section 3 says you are disqualified for running for office. So that's where they came from. But the Supreme Court decided to abandon their textualist roots, originalist roots, and decide to rule on principles of federalism and just common sense that we don't want 50 states to go in 50 different directions. There would be chaos.
All right, here's a little sample of that point, not to lump you in with these people, Dave, from reacting to this decision. This is given to us by the Media Research Center. Saw3, watch.
This is actually what I had been concerned about. I had been concerned that should it go to the Supreme Court, they would rule this way.
I'd laugh if it weren't so sad.
My next guest says Donald Trump is still an oath-breaking insurrectionist.
The court itself may have overstepped.
The court went way further than it needed to go.
Our colleague Melissa Murray has called this Supreme Court the YOLO court.
The criticism of the court is that they're playing interference.
Not since Bush v. Gore have we seen a court that's had this many opportunities to interfere in the election.
The headline here is that this is a unanimous ruling, but if you scratch the surface just a little.
This is a 5-4 ruling on part of it.
This is actually a 5-4 decision.
It's 5-4.
Trump will take this, spin it, spread the misinformation, disinformation on it.
You can't save a people from themselves.
Whatever happened to Larry Sabato? Remember him, Mike Davis, back in the Fox days? He was like a normal pollster that you could rely on for down-the-middle analysis. Now he's gone hardcore never Trump. But look, I understand the 5-4 argument for the reasons that we kicked the show off with. But on the core point, it was 9-0. And I wonder whether these same people are going to be so disgusted with the court and ready to dismantle it after the court is likely, Dave, to rule against Trump and his claims that everything he did in office is immune from prosecution when we get that decision in May or June.
They're going to rule against him on that, but they're going to drag their feet, and that will infuriate my colleagues. And I understand that, because if they continue to delay this matter, the trial in D.C. may not ever happen. So that's what they care most about.
What are you saying? The only people who dragged their feet were Jack Smith and the Justice Department. As soon as they filed the charges, Trump started to challenge it legally. Now it's gone up. Supreme Court took it. They could have kicked it to next fall. They didn't have to put it on this term, but they took it on this term. They're not dragging anything.
Well, compared to what they did here in the Colorado case, Megyn, where they expedited matters to give Trump a decision within weeks to make sure it was done before Super Tuesday, where they even issued an opinion on a Monday, which was so rare. And then you compare it to intervening in Jack Smith's case, where they first said, no, we're not going to intervene in December. No, we're not going to get in and Bigfoot.
That's because Jack Smith was trying to skip the D.C. Circuit Court of Appeals. That's the only reason they said not yet. They said, you got to turn. You got to go to the middle, guys, before you come to us, which, Mike, every Supreme Court would most likely prefer, because then you get a whole decision with reasoning from the lower court that you get to kick off the argument with. It wasn't unusual at all for the court to say, slow down, Nellie. You going back, you do it before the Court of Appeals and then you come to us.
Well, yeah, I mean, of course they have to decide this Colorado disqualification case as quickly as they can, because these states need to print ballots, right? And they need to print ballots and figure out whether Trump is going to be on the ballots or not going to be on the ballot. On this presidential immunity, they are deciding this case in like warp speed. They did.
Yes.
They set this case for oral argument in April. They're not allowing Trump to seek en banc review with the D.C. Circuit. They're not waiting until to hear oral argument in this case next fall or even next winter, as they should. That would be the normal course. They're very much expediting this, and there's no need for them to expedite this because it's not relevant to the election. Whether Trump is on the ballot is relevant to the election. Whether Trump has
the Colorado elections today.
Yes, I mean, look, I would say this about presidential immunity. I know you guys both disagree with me on this, but I seem to have a track record on this. The Supreme Court is going to find that the president, any president, is immune from criminal prosecution for his official acts. Then the Supreme Court is going to remand this case to D.C. Obama Judge Tanya Schuchat to hold an evidentiary hearing on what Trump allegedly did on January 6th that was in his official acts, like, he was going to fire his acting attorney general. That sounds pretty presidential to me, versus in his personal capacity. And then once they decide that, Trump can appeal that again, because you're dealing with immunity. And so the bottom line is that there's no chance this case is going to go to trial before the election. And I would say to these Democrats, Boo-hoo. You're going to actually have to vote for the president of the United States on November 5th, 2024, the old-fashioned way, instead of having your left-wing judges remove him from the ballot or throw him in prison.
Here's, take a listen to Jim Acosta on CNN talking about how sad this is and how Trump files all these appeals, delays everything. Not like a normal person, even though everybody in the United States who gets convicted or sued civilly and loses has the opportunity to file an appeal, which Jim Acosta, he should familiarize himself with the lovely service known as Google or any of its competitors, which we're moving to now, because this is not a special Trump thing. This is called being an American thing. Watch this.
Jim, what do you say to all those Americans out there who are watching this, who are frustrated and say, Trump is getting away with breaking the law, that he files appeal after appeal. He tries to delay every proceeding that's brought against him in a way that is it just goes against what our judicial system should be about. I mean, isn't he treated differently than just about everybody else in this country? I mean, just about anybody else would not have the ability to appeal things until kingdom come.
Well, actually, they do have the ability to do that. That's part of our justice system.
Well, but for all practical purposes, that doesn't happen. I mean, the vast majority of defendants out there don't have the resources to drag everything out in umpteen different cases across the country.
What?
Mike?
I mean, has he heard of public defenders? I used to clerk for Judge Gorsuch on the 10th Circuit. I used to clerk for Justice Gorsuch on the Supreme Court. We heard appeal after appeal after appeal from rapists and murderers and carjackers and these same Democrats who bemoan that, Trump's not above the law. They want Trump to be below the law. They want him to not have any rights. They just want to throw him in prison and bankrupt him and take him off the ballots after they impeached him twice for nonsense because they fear American voters. Why do Democrats fear American voters? Why do they not want American voters to have a choice on November 5th, 2024?
I'll tell you why. Keith Olbermann's going to explain it to you. I know you were waiting to hear from him. Here you go.
Of course I'm respectable, says John Huston as Noah Cross in the movie Chinatown to Jack Nicholson as Jake Gittes. I'm old. Politicians, ugly buildings, and whores all get respectable if they last long enough. And then there is what happens when you are all three of those things, as the Supreme Court is all three of those things. Politicians, pretending to be justices, working in an ugly building, and as Trump relied upon and yesterday was proven correct, they are all whores. And I have lots to say about the Supreme whores and what they have done and what they might yet do, which, improbably enough, includes making Joe Biden into an instant American king. Yet they are not the lead story. The evidence is mounting that what Donald Trump is suffering from is something called fluent aphasia. There are 2 million Americans with aphasia, a kind of catch-all for a series of communication disorders. And obviously this is a layman asserting this. I could be wildly wrong.
Yes. Some self-awareness at the end. I'll give you the first crack on that one, Mike, because I see you laughing.
Well, I would say this. I take offense to what he said about. Everything else he said was fine, but he said the Supreme Court building was ugly, and I take great offense to that because I think the Supreme Court building is beautiful.
I agree.
I agree with you.
We can all agree on that.
I know. It's absolutely beautiful. And the actual courtroom in which the justices sit is magnificent, has a bunch of history, and who knows whether Keith Olbermann's actually ever dragged himself out of his cave to go over and behold the majesty that is the Supreme Court building, but whatever. He's just fun. He's just fun to listen to. I'm not going to lie. I'm kind of glad he's in the national conversation just because he's entertaining, but literally nothing he says is right. I mean, it's either offensive or wrong or both, which is why we go to him a fair amount. Okay, so it's done. The insurrectionist thing is over, and there's plenty more to discuss on the legal front. All right, now that brings me to, I'm going to figure out what I want to do next. Okay, January 6th, that's the underlying case with Judge Chutkan. this is actually getting very interesting. So her entire proceeding is delayed. It's frozen while SCOTUS, in a separate matter that we made a reference to, tries to decide whether Trump is immune to that prosecution entirely. So it's frozen. She can't do anything on it. And Politico comes out with an article entitled, "The Enormous Pressures About to Land on Judge Tanya Chutkan." And in this piece, the author makes a reference to the fact that Jack Smith, who's both pursuing the January 6th federal case against Trump and the Mar-a-Lago documents case against Trump in Dave's jurisdiction, had an appearance before the Florida judge in the Mar-a-Lago case recently and said to that judge, Aileen Cannon, there are no DOJ policies that prevent cases that have already been charged from going to trial in the run-up to the election, even if the defendant is on the ballot. All right, notwithstanding this, supposed DOJ policy that they would not do anything to interfere with an election within 60 days of the election. They wouldn't charge a candidate. They wouldn't do anything like that because they don't want to influence the vote. Now they're saying to Judge Cannon, we're actually not going to follow that in this case. It doesn't apply because we charged him well before. And so now there's real speculation about whether Judge Chutkan should go ahead with this trial as soon as the U.S. Supreme Court gives it any sort of a green light, should rush it to trial, in fact. And the suggestion is that she could hold the trial only 3 to 4 days a week, leaving Trump the remainder to travel the country and campaign. Hold the trial on alternating weeks, allowing Trump to campaign in the weeks in between his criminal trial in D.C. Hold half-day trial days, leaving Trump the remainder of the day to travel to closer states right around Washington, D.C., and to campaign nationally through his media appearances. And then the writer goes on, and Kush Kardori, to say, you know what, the trial also does not need to even end before November, though that's far from ideal. They can keep this thing rolling, and potentially you could get him convicted even after he wins, and then he could be, I guess, kicked out, not certified. I don't know what the end plan would be if they got his conviction between November and January. But my takeaway on this, I am coming back to you, Dave, but let me just give this one to Mike first too, is that these Democrats will stop at nothing. He can campaign in the afternoon in the states around Washington, D.C. in October 2024.
Yeah, remember, they waited 30 months to bring these charges. And these are coordinated charges with the Biden White House and the Biden Justice Department. I've given you specific names in each one of these cases where they're specifically coordinating. You had Nathan Wade, for example, billing his time to meet with the Biden White House and the Biden White House counsel, right? You had Matthew Colangelo going from the Biden Justice Department, the number 3 office, to Alvin Bragg's office to bring the first indictment ever against a former president and a likely future president. You had Jonathan Sue, Biden's deputy White House counsel, waive Trump's claim of executive privilege on behalf of President Biden. So you have Biden's fingerprints on all 4 of these things. You had Biden going out there leaking that Garland was acting like a professor instead of an attorney general. And so then Garland moved forward. And we have these 4 coordinated indictments and criminal charges against Trump. And they've timed these trials back to back to back right during the 2024 presidential election season. And Jack Smith will probably convince D.C. Obama Judge Tanya Chutkan that he can do this. Maybe he'll convince Judge Cannon. But here's the deal. The legitimacy of the judicial system is on the line. When the American people start paying attention and they see President Trump in a courtroom for these bogus charges instead of on the campaign trail, this is not going to go well with the American people. And when the justice system loses its legitimacy with half of the American people, they're going to lose a lot of their funding.
I mean, Dave, if this is the Democrats' campaign strategy, this is the thing that Biden thinks will win him the election. That, as again, quoting here from Andy, who's making a reference to Adam Liptak of the New York Times outlining the possible plan. A felony trial of Trump on the January 6th charges before a hostile Washington jury pool and an unfriendly Obama-appointed judge beginning after Labor Day, running through Election Day. That is the Biden campaign strategy. It's outrageous. It could work, I guess. Do we have a judge in Judge Chutkan who would go along with this?
Megyn, there is absolutely no evidence that Joe Biden has been pulling the strings on any of this stuff. Remember, he, and I would agree, is frustrated with Merrick Garland because Merrick Garland, the one thing I will agree with what Mike said is that he slow walked a lot of this stuff. He is timid, and I don't think he was the right pick for attorney general. But he finally appointed a special prosecutor, and then it was on. Remember, this is the same attorney general who's prosecuting Joe Biden's son, the same guy who let Robert Hur become the special counsel and then release this report bashing Joe Biden's mental acuity. And as far as the Department of Justice and this 60-day rule, there has never been a rule that says you cannot try a case before the election. Just ask Senator, well, he's not around anymore, Senator Ted Stevens of Alaska. He had a trial for his fraud claims, his criminal activity in late September of the year where he was up for re-election. In fact, the jury gave a guilty verdict a week before Election Day. So this has happened before. It's not a surprise it's happening now. And if anything, I got to tell you, I think the Supreme Court was dragging its feet. I know we've talked about this, but one other thing about that, they didn't have to intervene in this matter. They didn't have to wait 2 weeks to then say, yeah, we're going to get involved. And then when they did so, even after they granted cert, they didn't have to issue a stay. And then they could have had the oral argument like now, like in March. It's all teed up. You don't have to wait till the end of April. So I look at it from a different perspective. Not only is there no coordination between Biden and the prosecutors here, but it looks like the Supreme Court has been intentionally dragging its feet to make sure justice is not served before the election and voters don't get the information they need to make a rational choice.
I'm gonna have to bust out my mother's cupboard again, aren't I, Dave? Lack of planning on your part does not justify an emergency on my part. She used to whip that thing open whenever I'd be like, Mom, I need you to pick up my school report and bring it. I forgot it. No, they drag their feet. Now it's not up to the Supreme Court to suddenly have to go faster than that aircraft carrier normally goes. It's just not how things work there. But I will say, Mike was nodding his head yes, whether Judge Chutkan could actually help them engage in this strategy on J6. But here's the thing I want to get back to. Andy's saying, Mike, the DOJ pointing out, even if Trump wins in November, and Mike Davis is his AG elect, right? Or is it the one that he's going to appoint? You will not be in power until January 20th, 2025. And he writes, remember, a president-elect is in no position to dismiss anything. There may be more than enough time between September and January to get Trump not only convicted, but sentenced. Jack Smith is banking on at least the former, the conviction, and he'll push for the latter too if it's remotely attainable. My God, so that he's I hadn't even considered this scenario, Mike, where they do press forward on J6 trial before Judge Chutkan after the Supreme Court rules, if they allow this case to go forward in any way. And I realize the whole heart of that case may get gutted by another case that they're about to hear, Fisher. That's another matter. That they might put pedal to the metal, make him do the half days or the 4 days a week, what have you. He wins the election. And between November 5th and January, they get a conviction and sentence him to prison. What happens then? Does anyone have any idea what happens then?
And that's why this Jack Smith is a Scud missile that the Democrats send in, and he is so reckless. Remember, he was overturned 9-0 when he brought his bogus corruption charges against former Virginia Governor Bob McDonnell, a likely presidential or vice presidential candidate in 2016. He was able to win his conviction and destroy Bob McDonnell's political life and personal life. And then the Supreme Court 8-0 reversed him in 2016. It would have been 9-0, but Justice Scalia passed away, right? But that's exactly who Jack Smith was. He got banished to The Hague because he is a partisan buffoon prosecutor. And then Garland brought him back as the Scud missile to take out President Trump before the election. This is all about election interference. They're not even hiding it anymore. It's very blatant that what they're doing is they're trying to interfere in the election. They don't care what the American people want. They fear American voters. And so they're trying to bankrupt, disqualify from the ballot, and put Trump in prison because they don't want the American people to put Trump back in the White House.
Okay, Dave, I think the answer to my question is we don't know, right? It's truly unprecedented to have a president-elect get convicted of a felony and be sentenced to jail after he's been elected, but before he's been sworn in. Like, I don't think we know. We're on uncharted grounds here, are we not?
Agreed. We don't know. And I get asked that question all the time. You can run for president from prison. You could technically serve as president from prison. What will be interesting, if he is convicted and then he takes office, I assume there would be a stay. I assume there'd be an appeal and his sentence would be stayed, and then he would go into the White House, and then nothing would happen until after he's out. I think that's why he's running for president.
He can pardon himself, right? Once he's sworn in, he can pardon himself.
Well, it's not clear whether that would stick. He can try. He could also resign temporarily under, I forgot which, Mike can help me, which amendment, where the vice president takes over briefly and then pardons him. And then which one is it, Mike?
25th.
There you go. 25th. So that could happen. But, the reason why Donald Trump is running for president is because he realizes this is the best way to escape all the legal liability swirling over his head, and it may just work.
So far, it is working. All right. So there are other developments still going. Some crazy ones out of New York, too. I'm going to take a quick break and come back. The legal news today is actually really interesting. We haven't even gotten to Fannie. We have to ask if our guys can stay just a little later. We'll do that during the break. Mike and Dave, stay with us. Financial experts thought we were in the clear. They were anticipating around 6 rate cuts by the Fed this year. And then the inflation data came out and higher than expected. This is not going away. How can it? We're $34 trillion in the hole in America, and yet we keep printing the money, which pushes the prices you pay even higher every day. So you can either bury your head in the sand or you can do something about it. One option to consider is to diversify a portion of your savings into gold with Birch Gold Group. Gold can be your hedge against inflation, and Birch Gold makes it easy to own. They will help you convert an existing IRA or 401k into a tax-sheltered IRA in gold, and you don't pay a penny out of pocket. Text Megyn, M-E-G-Y-N, to 989-898, 989-898, and get your free info kit on gold, and then talk to a precious metals specialist about how you can choose to protect your savings from persistent inflation with gold. Text Megyn to 989-898 now. One final point that we raised the other day, Andy raised it too in this piece, and I thought it was important. In the Florida case by you, Dave, they went in there, both sides, and said, okay, how about a summer trial date? The prosecution said, we want July, or I think July 8th. And Team Trump said, no, that's too soon, but we could do August 12th. And no one really thinks that case is going to go off on August 12th, but the thinking is that what he was doing there was getting a placeholder on that case so that Judge Chutkan over in D.C. and all the peril I just described there can't go anytime soon, because they're not going to make Trump sit for simultaneous criminal trials. So one is going to have to go before another. So Team Trump appears to have thought, okay, better to have that one on the calendar than Judge Chutkan. Let's keep her at arm's length. But Andy makes the point that, well, the downside to this is Trump's lawyers have now undermined their credibility to argue to Judge Chutkan that the Biden Department of Justice must not be allowed to subject Trump to a criminal trial during the campaign stretch run. So how could that manifest? The Judge Cannon in Mar-a-Lago would say, you know what, we're not doing it on August 12th. I know we had a placeholder, but too much to go through, so no. And then suddenly this big, beautiful window of time opens up and Judge Chutkan says, I'm back from my European vacation and I would love to do it. And at that point, is he saying like Trump would be unable to argue, oh, but it's not fair because he already agreed to in another jurisdiction?
It hurts his argument, but Trump said that they can't do it before the election. And then he was pushed by Judge Cannon to say, give us a date. You got to give us a date. So then they said, okay, August 12th for the reasons that you and Andy have mentioned. They thought it would block Judge Chutkan's future calendar. But it is correct that now they can use that against him. But when it comes to Judge Cannon, it won't matter. That case is not happening before the election. Judge Cannon is going to give in to Trump's demands to delay it. Where it could come into play is, yes, with Judge Chutkan, when Trump says we can't do it right before the election, then Judge Chutkan says, you gave them August. So that is a real possibility. And yes, she has said she's going to ditch her European vacation to come back and try this case. So kudos to her.
Sure. She's like, this is vacation for me. This is the happiest place on earth, not Disneyland. Okay, let's jump to New York for a minute. There are big updates today on Fannie. I'm going to save it to the top of the hour. Via Katie Fang of MS. Donald Trump has until later this week to post a $91.63 million bond to stay the execution of E. Jean Carroll's judgment against him. This is the civil case for, first it was sexual assault, and then the big judgment was for him allegedly defaming her. And Newsweek says, of course, in New York, a person must pay a court cash bond that amounts to 110% of the judgment to appeal the ruling of a civil case. That's why it's more than the $83 million that was ordered. So he has to pay $91 million in bond to stay the execution of that civil judgment against him as he tries to appeal this. On Monday, Judge Lewis Kaplan said he would not reach a decision on Trump's motion to stay the execution of this judgment, but he will render a decision soon. So, Mike, what does this mean? Is Trump going to have to post this bond for $91 million? And is he then going to have to post the bond for the $500 million judgment that's been handed down against him in the corporate fraud case against the smiling Judge Engoron?
I mean, that's the problem. I mean, so what is Trump going to have to liquidate assets to pay the bonds on these bogus judgments up in New York? I mean, they changed the law in New York for this nut job Jean Carroll's bogus claims against Trump. I don't have any money, Jean Carroll, so go ahead and try to sue me. I was going to say, she's going to sue you. She's going to... Go ahead, sweetheart. But, here's the deal. I mean, Trump's going to have to liquidate his assets. He's going to have to post these bonds, or they're going to go in and take over his buildings and do fire sales. This is this is part of the Democrat lawfare. They're doing this on many fronts. They're doing this on the disqualification front, the impeachment front, the 4 criminal indictments. They're trying to bankrupt him for non-fraud. They're trying to go after him for $100 million with Jean Carroll. This is lawfare and election interference. And Democrats may be gleeful about this right now, but they're not going to be very gleeful when Donald Trump essentially runs over their puppy with a lawnmower on November 5th, 2024, and he wins back the White House.
What an image.
That's Dave, a terrible image.
Terrible image. Dave, I really am interested in this because when he tried to get the New York Appeals Court to reduce the amount of bond he had to post in that $500 million judgment against him, the judge said no. Now he's trying to get a larger panel of the appellate court to reconsider this, arguing that it's an excessive fine under the 8th Amendment, which prohibits cruel and unusual, but also excessive fines. And so far, these judges are all saying, no. Post the bond. The one judge said you can, on the $500 million, they said, we'll let you go get loans. All right, if you want loans, you can go get loans, because originally that crazy Judge Engoron said you can't even get a loan for this from any bank that even does business in New York, which rules out every bank in the world. And so they said, all right, you can get a loan. But what's going to happen? Because there's a Wall Street Journal piece today really talking about how Letitia James is threatening to seize his properties. And while that's really not the state's first choice, because they don't know how to run buildings or sell buildings, that what else can they do? That's their threat. And if he doesn't post the bond, that would have to be their next move.
Right. I do think he'll get loans to pay off the bonds, but you're correct, Megyn. This is a real threat to Donald Trump, and he takes this very personally when you go after his finances. But this is where his own rhetoric hurts him, because when he says how rich he is and he has way more money than people know, the courts use that against him. So a lot of this is his own braggadocio.
Dave, how's he
going
to
to
get the loans? But how is he going to get the loans? Because I understand he's got some money, but if you're a bank and you see how leveraged he is right now to the tune of over $500 million, I can see you not wanting to loan anything to Donald Trump. My own fear is like the Saudis are going to be like, hey, we'll do it. And then he owes the Saudis, which we don't want in our future president.
That is a real concern. That's something, Megyn, that I think we can all agree on. We do not want that. Now, Trump does have an asset that could be blowing up financially, which is the Truth Social, where he could be in line for a couple $1 billion. So he could put that up as collateral. So that's something that he could use to get a loan.
All right, that's better. Mike, am I wrong to fear like China coming in and saying, we can cover the $500 million bucks. Here you go.
Yeah, I mean, it would be very bad to have a president of the United States corrupted and compromised by foreign loans and payments, from China, from Ukraine, from Russia, from Kazakhstan, from Romania, every other trouble spot around the world. I mean, I'd hate to see a president of the United States or his family members take any money from these foreign countries. Oh, wait, well, how about the Bidens and the Biden crime family?
Okay, this would dwarf that on a massive scale, but I'm against it. I want to go on record and say I'm against it for Biden. I'm against it for Donald Trump, too. I really hope this doesn't happen, but this is kind of the position he's being placed in. I mean, what would you do if you were Donald Trump? Would you sell Trump Tower so Letitia James could get it just to give to these Democrats in Albany who are busy taxing us to our eyeballs? There's no victim who's going to get this money. All right, stand by. Fanny's next, and there's 2 new witnesses in the case. Don't go away. I want to tell you about the Association of Mature American Citizens, or AMAC, an organization dedicated to America's seniors. AMAC stands out today by not only advocating for senior issues, but also by pushing for conservative values that affect us all. Don't you want a group representing you that actually shares your values? If you join, you're not just supporting America's senior citizens, you can become part of a movement defending our freedoms and securing our nation's future. Plus, membership brings you exclusive benefits like discounts on travel, dining, entertainment, and special insurance rates. Regardless of your age, if you're driven to preserve freedom, AMAC welcomes you. Sign up now at amac.us/Megyn. That's amac.us/Megyn. And for a limited time, get a free gift membership for someone who shares your love of our great nation. Don't miss out on this chance to make a difference with AMAC. Join today at amac.us/Megyn and extend the invitation to a friend or family member for free. And before we get to Fannie Willis, I've got to tell you, this has been reminding me of something. I've made this reference before. It's one of my favorite movies, and it should be one of everyone's favorite movies. This Keith Olbermann little rap that he did today on the Supreme Court and that he did last week on the Supreme Court. Remember, here it is.
The conservatives on the Supreme Court are Trump's whores. Chief Justice Roberts is a Trump whore and he can burn in hell. And Justice Alito is a Trump whore and he can burn in hell. And Justice Gorsuch is a self-contradicting Trump whore and he can burn in hell. And Justice Kavanaugh is a drunken abuser Trump whore and he can burn in hell. And Justice Barrett is a handmaid Trump whore, and she can burn in hell.
Reminds me of Tommy Boy. Stand by.
And that's when the whores come in.
Here we go.
God bless Chris Farley.
God bless Chris Farley. We can all agree on that. He's obsessed. The man's obsessed. I'm just telling you, there's some sort of a revelation in his constant focus on whores. I'm just going to put it out there. There's some sort of a revelation. I leave it to the audience to figure out what that is. Okay, on to Fannie Willis, where there is new news. Not one, but 2 witnesses have now come forward to various defendants saying that they would like to and are ready to testify. They are both saying, shocker, Terrence Bradley is full of BS. The lawyer who once represented Nathan Wade for a short time and was Nathan Wade's friend. And when he took the stand, notwithstanding all of his admissions to attorney Ashley Merchant before he got to the stand about, yes, I know when it happened. It was long before they said they were lovers. It happened when she left the DA's office as a junior person and became a judge in 2019. And then he gets on the stand, doesn't remember anything. Two other people are like, he talked to me like that too. He told me all the same secrets he told Ashley Merchant and went on and had great detail. So it wasn't just the texts to Ashley. All right, number one is a woman named Cindy Lee Yeager, who is not just some rando. Cindy Lee Yeager is currently the co-chief deputy DA for Cobb County, the neighboring county. This is Fulton County for Fannie, but kind of next door. This is the co-chief deputy DA. So this person also has an obligation of candor to the court. And she's apparently ready to take the stand if the judge, because he's still considering whether he will reopen the evidence or whether he even needs to reopen the evidence. And she says from August of 23 through January of 24, all right, so basically this past fall, that's the same time Ashley Merchant was talking to Terrence Bradley, that she had numerous conversations with Bradley as well, in which he was talking about his favorite subject, Willis and Wade and their romance. According to the filing, he told Ms. Yeager that relationship began, see if this sounds familiar, guys, around the time that Willis and Wade met at a judicial conference in 2019. Wade, quote, had definitively begun a romantic relationship with Ms. Willis during the time that Ms. Willis was running for DA, which is 2019 to 2020. Mr. Bradley stated that he had personal knowledge of this relationship and included details regarding Mr. Wade's use of Ms. Willis's use of Robin Yurti's apartment and other meetings between the two of them prior to November of 2021, which is when he filed for divorce and got hired by Fannie. Mr. Bradley told Cindy Lee Yeager, she alleges, again, this is an officer of the court saying this, that Mr. Wade personally prepared his own divorce complaint against his spouse and told Terrence Bradley, you just sign the divorce filings and file them, suggesting that the actual attorney-client relationship did not begin until around November of 2021 and not back in 18, as Terrence Bradley testified. And they say, based upon these statements, it is Ms. Yeager's understanding that Mr. Bradley did not begin representing Mr. Wade until November of 2021. All right, now, just going to give you the second thing. This happened this morning, moments ago. Another person has come forward, another officer of the court. His name is attorney Manny Aurora, former adjunct professor at Georgia State School of Law. Apparently, he's a friend of Terrence Bradley's. Terrence Bradley, he talked a lot. He spoke to Terrence Bradley, says Manny, and he's willing to testify that Terrence Bradley, same time period, September, October 2023, this past fall, regarding the relationship between Willis and Wade. Aurora claims that Terrence Bradley told him the relationship began when Willis was running for DA in 2019 through 2020, that Bradley had personal knowledge of the relationship, including details regarding the use of Robin Yurti's apartment. That's exactly what the other one said. Personal knowledge, including the use of Robin Yurti's apartment, and he adds that Mr. Wade, this is what this guy learned from Terrence Bradley, had a garage door opener to the property. This rung a bell with us because Ashley Merchant, I think, was also told this by Terrence Bradley because she raised it when he was on the stand. We pulled the SOT. Watch.
Do you recall that he had a garage door opener to either a house or a condo or something like that of Miss Willis's?
I've never seen a garage door opener, so no, I do not have any personal knowledge of him having a garage door opener.
Do you have any knowledge at all from Mr. Wade or any source that he had a garage door opener to access one of Miss Willis's residence?
And I'll object to any source as to hearsay.
All right, depends on the source. Overruled.
No, I don't have any knowledge.
Well, it's clear that Ashley Merchant got that from somewhere. It appears to have been him, but for sure, we've got a lawyer named Manny Aurora who's willing to take the stand and say, he told me, Terrence Bradley told me Mr. Wade had a garage opener to that property. And again, we have another witness, a DA, saying he told me that they were having an affair at that time and had details about the use of her apartment and other meeting. I mean, the little butterball turkey, the thing has popped out. It's done. It's done. Dave, is it done? Am I like, how many witnesses have to come forward to put the lie to this?
It's only done if they had firsthand information. What they're doing is just, again, saying that Terrence Bradley lied on the stand. He was out there saying things, and he has clearly loose lips. And then when he got in the stand, he said, well, I was just speculating. So I think that's what would happen here. He'd get put on the stand. He'd say, I was just speculating. I was talking trash. And so I don't think that moves the needle as much as something else, Megyn, that you may have seen, where the first witness, Yeager, said that she heard Fani Willis's voice on a phone call to Bradley talking, and that would contradict actually. Yeah, that I think is a bigger deal than this. This to me, Megyn, because it's not firsthand information, does not move the needle, and I don't think that the judge is going to reopen it just for this. It's that other thing which we'll talk about, which may be a bigger problem.
I'll just fill it in now. This first witness, this assistant deputy DA in Cobb County, is willing to take the stand and tell this judge under oath that Fani Willis was calling Terrence Bradley when Bradley was visiting Yeager in September. So Bradley was with Yeager and he got a phone call from Fani. And she was calling Bradley in response to an article that was published about how much money Nathan Wade and his law partners had been paid in the case. She was mad because the press was going off about how well compensated this one guy was with no relevant experience in prosecuting RICO felonies and so on. And Ms. Yeager personally heard DA Willis tell Terrence Bradley, quote, "They are coming after us. You don't need to talk to them about anything about us." Us. An obvious reference to Fani and Nathan. Mike, all of this undercuts Terrence Bradley trying to claim he knew nothing on that stand, and of course the underlying under oath assertions by Willis and Wade about their affair.
Yeah, I mean, this is a train wreck. And I would say about this Terrence Bradley, look, he's a lawyer. He was a law partner with Nathan Wade. Why is he running his mouth? Look, why is he running his mouth? Just keep your damn mouth shut. Even if it's not exactly an attorney-client relationship, or it may or may not be. If you're a law partner, if you're a previous lawyer, future lawyer, just keep your damn mouth shut. Why is he running his mouth to all these people? It's just, I know that why. To me just makes me not like him at all.
I know why. I don't know. This is my opinion. Is he's mad he got pushed out of the firm over allegations of sexual assault that he denies. So he doesn't have, and then that's when his relationship with Nathan Wade, at least as a lawyer, ended, he testified. And that was, I think, summer of 2022, or maybe September of 2022. So he's probably pissed off a little that not only did they push him out of the firm, but he got accused of being a terrible person, of like sexual assault, again, which he denied on the stand. And so while it appears they had some contact going forward, it wasn't particularly close. He denied that they had any contact. But now we had this guy calling Ashley Merchant, leaving the voicemail saying, "I served them having lunch together a couple of weeks ago." So Nathan Wade and Terrence Bradley, and that I know these players. I knew exactly who it was, and I introduced myself, and like just all the bricks are falling out of this wall for Terrence Bradley. And why? Because he's embarrassed that he did blab inappropriately on a friend, and worse, potentially on a client, but he did blab and it's out there. And for better or for the worse, I don't know, you tell me. The judge is a human. There's no sequester order on him and media, Dave. So he's going to know this, and he's got to review these motions to see whether he's going to allow these people to testify.
Right. I agree with everything you and Mike said about Terrence Bradley. Remember when Fani Willis's lawyers went after him? We didn't understand why. So why go after your own witness? He's given your side whatever you wanted, but now we know because I guess they anticipate all this stuff coming out. And the fact is he did have a bad breakup with Nathan Wade. And so, yeah, this is something the judge is aware of. The judge may have already made up his mind and this doesn't matter. But if the judge has not, or if he's ruling for Fani Willis, then he's more likely to allow this to come in. I still believe the only thing that really is relevant here is that conversation that Yeager heard herself of Fani Willis's voice talking to Terrence Bradley.
I'm just going to say, Mike, how do you speculate that he has a garage door opener that he uses to access this apartment owned by Robin Yurty where he's visiting? That's quite a speculation.
And very specific, a very specific speculation. I mean, this case is a mess. I don't know if Dave is with me now that this case, they should absolutely get disqualified from this case, and this case should be dismissed with a new prosecutor brought in because it is so corrupted. I would say to the Democrats, why would you use these corrupt, lying buffoons as your front people for the lawfare against a former and likely future president of the United States? If you're going to run lawfare in 2028, pick better people next time.
I think that's good advice. That's free legal advice. I agree with that. And I want to tell the audience again, tomorrow at 9 a.m., Ashley Merchant will be taking the stand in front of the Georgia Senate committee that's investigating this. They've subpoenaed her and all of the texts between Ashley Merchant and Terrence Bradley. They've already interviewed what they say are whistleblowers in this case, though we don't know anything more about that. So we're expecting to learn a fact or two directly from Ashley Merchant tomorrow when, interestingly, she takes the stand. All the lawyers are taking it. Pretty soon, Dave and Mike are going to have to take the stand, and I'm going to take the stand. We're all going to be, but we'll tell the truth. Guys, thank you so much. We appreciate it.
Thank you.
Thank you.